In this video, I will give you the latest case processing update from the National Visa Center. Plus, if you were affected by the past travel bans and your case were denied, you may not have to pay a new immigrant visa processing fee. So keep watching for more details. Hey guys, welcome back to Itascorner. My name is Ita. How are my amazing immigration friends doing? How has the year been treating you thus far? Well, your girl has been going through it. It has been a dunghill battle for me, but I thank God for life. I thank God for this channel, and I thank God for you guys. And that note, let's go ahead and give a quick shout out to my new and returning subscribers. To my new subscribers, know that I see you and I'm here for you. To my returning subscribers, thank you. You guys are amazing and very patient with me. Know that I love you, and this channel will not be where it is all because of you. If you haven't subscribed yet, what are you waiting for? Go ahead and pause this video right now and smash the subscribe button. Let's get to 4,000 subscribers by the end of February 2022. I know we could do it. On that note, let's get straight to the video. Here is the latest case processing update from the National Visa Center. As of January 24th, 2022, the National Visa Center stated that they are working on cases received from the USCIS on January 11th, 2022. They are reviewing documents that you submitted to them on October 20th, 2021. And lastly, they are responding to inquiries that you sent them on December 1st, 2021. In conclusion, in terms of working on cases received from the USCIS, they are 2 weeks behind. Reviewing documents, they are 3 months behind. And lastly, in terms of responding back to your inquiries, they are 1 month, 4 weeks behind. Now let's go ahead and take a look at the latest regulation regarding immigrant visa exemption fee if you were affected by the past travel bans. For example, the Muslim travel ban. Immigrant visa fee exemption for applicants previously refused under Presidential Proclamations 9645 and 9983. On January 19th, 2022, the Department of State informed the public that on January 20, 2021, the President issued Presidential Proclamation 10141 titled Ending Discriminatory Bans on Entry to the United States. This proclamation revoked Presidential Proclamations 9645 and 9983, which had suspended entry into the United States of certain nationals based on visa type from Burma, Eritrea, Iran, Kyrgyzstan, Libya, Nigeria, North Korea, Somalia, Sudan, Syria, Tanzania, Venezuela, and Yemen. The Department of State has amended its regulations at 22 CFR 22.1 and 42.71, governing immigrant visa fees to exempt from immigrant visa fees certain applicants previously denied an immigrant visa solely due to Presidential Proclamations 9645 and 9983. Effective immediately, all immigrant visa applicants previously denied an immigrant visa on or between December 8, 2017 and January 19, 2020 with the sole ground of ineligibility based on Presidential Proclamations 9645 or 9983 are exempted from paying a new immigrant visa application fee or affidavit of support fee if applying again for an immigrant visa. Applicants do not need to pay a second fee if the following conditions are met. Number 1, the immigrant visa applicant was previously denied an immigrant visa on or between December 8, 2017 and January 19, 2020, and the sole ground of ineligibility was based on Presidential Proclamations 9645 or 9983, and the applicant is applying again for an immigrant visa. This amendment is not retroactive and no refunds will be distributed based on this change to the regulations. This provision provides for a one-time exemption of the applicable fees per applicant. Prior to this amendment, Department regulations at 22 CFR 4281E already provided that an immigrant visa applicant is not required to pay a new application fee when seeking reconsideration of a visa refusal within 1 year of the refusal date by providing additional evidence that overcomes the ineligibility on which the visa was denied. Individuals who were refused on or after January 20, 2020 may benefit under that regulation and fee exemption because they are presumed to have sought reconsideration of their prior refusals on January 20, 2021 and the President issued Presidential Proclamation 10141. Now let's go ahead and take a look at the frequent asked questions regarding this new exemption fee for immigrant visas. Question number 1. I already paid a second immigrant visa application fee. Can I get a refund based on this new regulation? This amended regulation took effect on January 19, 2022 and only applies to applicants who applied for their immigrant visa for the second time on or after the effective date of the new regulation. No refunds will be distributed based on this change to the regulation. Question number 2. My visa application was refused pursuant to Presidential Proclamation 9645 or 9683, but I was also refused on additional grounds. Am I still eligible for the fee exemption? Some applicants may have been initially denied immigrant visas under Presidential Proclamation 9645 or 9683 and additional refusal grounds. These applicants are not eligible for the fee exemption unless a consular officer had previously determined that the refusal on other grounds have been overcome and the only impediment to issuance of an immigrant visa on January 20, 2021 was due to Presidential Proclamation 9645 or 9983. Question number 3. My visa application was refused based solely on Presidential Proclamation 9645 or 9983. But my visa application was refused after January 20, 2022. Am I still eligible for the fee exemption? Although this final rule does not apply to immigrant applicants who were refused on or after January 20, 2022, Department regulations at 22 CFR 42.83E already provided for the reconsideration of the previously filed application without an additional application fee. That regulation allows immigrant visa applicants to have their case reconsidered without the payment of an additional fee by providing further evidence tending to overcome the grounds of ineligibility in which the refusal was based within 1 year of the date of refusal. The department considers Presidential Proclamation 10141 issued January 20, 2021 as the presentation of evidence overcoming the ineligibility, thus allowing cases refused within the prior year to be reconsidered under 22 CFR 42.81E without a new application fee. And lastly, question number 4. My DV 2020 application was refused pursuant to President Proclamation 1945 or 9983. Am I exempted from paying a new fee? Generally, U.S. law requires diversity visa (DV) selectees to obtain a diversity visa before the end of the fiscal year, example, September 30th, for which they were selected. For that reason, diversity visa selectees from the 2017, 2018, and 2019 program years are not eligible to make a new application and cannot benefit from this rule. However, the Department of State is aware of a court order in Gomez versus Trump regarding reservation and adjudication of DV 2020 diversity visas by September 30th, 2022. A DV 2020 applicant who was solely under Presidential Proclamation 9645 or 9983 may benefit from the fee exemption provision discussed here. The Department of State also stated that they will publish additional public guidance regarding the department's compliance with the Gomez court order as it becomes available. So you could follow this website here for more information. Diversity visa applicants from 2021 program year cannot benefit as they would have been refused after January 20, 2020. The fee exemption only applies to those refused on January 19th, 2020 or earlier. Now let's go ahead and recap what we have learned from this new immigrant fee exemption. Here are the main points of what we have learned from this new immigrant visa exemption fee due to Presidential Proclamation 9645 and 9983, which is also called the Muslim travel ban. I will list the countries that were affected by this travel ban down below. Now you are exempt from paying a new immigrant visa fee if your immigrant visa was solely denied due to Presidential Proclamation 9645 and 9983 between December 8, 2017 and January 19th, 2020. No refunds will be returned back to you if you have already applied prior to January 19th, 2022. If you were refused based on Presidential Proclamation 9645 and 9983 and on additional grounds, you will not be eligible unless the consular officer determine that the refusal on the other grounds had been overcome and the only obstruction was due to Presidential Proclamation 9645 and 9983. Also, diversity visa selectees from 2017, 2018, 2019, and 2021 are not eligible to make a new application and cannot benefit from this new rule. This fee exemption only applies to those refused on January 19th, 2020 or earlier. So this is it, guys. If you have any questions, make sure that you comment down below. You can always send me an email and you can schedule a consultation with me. If you know someone who was affected by this travel ban, make sure you share this video with them, okay? Because the more we know, the better. This fee exemption pertains to your visa processing fee and your affidavit of support fee. So if you know someone who was affected by this travel ban, they could definitely save a couple bucks from reapplying. Okay, so make sure that you share it with your friends and family, and if you have any questions, make sure that you comment down below. Before I go, have you gotten your Itascorner t-shirt yet? Follow the link that I listed down below, or you could check out the video description box for more information on how you could get your Itascorner t-shirt and take advantage of my discount code. Before I go, make sure that you subscribe, share this video, give it a thumbs up, and turn on your notification bell so you never miss another video from me. Thank you for watching Itascorner, and I'll see you next time. Bye now.